Good evening or good afternoon, wherever you may be. Everyone is here and I believe we're ready to get started. So we will call the case of Marks versus Sunny Rooftop Bar. My name is Judge Rein O'Neill. I'm going to ask the scoring judges at this time to look at the two buttons in the lower left corner of your screen and turn off your video and make sure that your audio is turned off. And for these additional scoring judges, just make sure that you keep your audio and video off until the trial ends. The other thing to make sure for our scoring judges is that you have your video settings set to hide all non-video participants. If either of the scoring judges has any questions about that or are having trouble doing that, please let me know or let Ms. Falkenstein know. Okay, so right now the only person on the screen should be me, and I'm going to now ask the advocates to turn on their videos so that we can make our initial appearances. Good afternoon or evening. I'm going to ask counsel to identify themselves for the record. I'll start with plaintiff's counsel.
Good afternoon, Your Honor, members of the jury. My name is Owen Stone, and I represent the plaintiff, Ethel Marks, in today's case, alongside my co-counsel, Caleb Kopitsky, and Miss Morgan Levin.
All right, good afternoon, Attorney Stone, and for the defense.
Good afternoon, my name is Johnny Winn, and today, with my second chair, Haley McDougall, today we will represent the defendant, the establishment Sunny's Rooftop Bar.
All right, good afternoon, Attorney Winn. Before we proceed to opening statement, I just wanted to see if there were any preliminary matters that either counsel would like to address with the court. I'll start with the plaintiff.
Thank you, Your Honor. A few brief ones.
Sure.
First, pursuant to Rule 603, we ask that all witnesses be constructively sworn in.
All right, that is granted.
In addition, we ask that pursuant to Rule 615, all non-party representatives be constructively sequestered. Any
objection from the defense?
No objection from the defense, Your Honor.
All right, that request is granted.
And finally, we'd like to ask your permission, your preference for screen sharing. Would you like us to ask every time we screen share or simply reflect on the record that we have begun screen sharing exhibits?
You just need, anytime it's appropriate to publish an exhibit, you may freely use the screen share feature to publish an exhibit. So to the extent that you don't need to ask separately for screen sharing purposes, if it's okay to publish, then you could go ahead and do that. Does that make sense?
Yes, Your Honor. And if before an exhibit's been entered, we ask that it just be constructively sequestered from the jury, but still be allowed to be shared on screen.
Yeah. Is there any issue or objection with that procedure from the defense? Otherwise, I don't have any issue with that, but I'll hear from the defense.
No, I have no problem with that, Your Honor.
All right, that procedure is granted and it's understood constructively that the exhibits, although shared for the purpose of laying foundation prior to being admitted, they will be allowed to be presented on the screen and we'll pretend like they're not there until they're admitted. Does that sound all right?
Yes, Your Honor.
Very
and with
good.
that, the plaintiff is ready to proceed.
Very good. From the defense?
Yes, Your Honor. I ask that upon the admission of video exhibits, do you prefer that we just show the still of the video or play a few seconds of it for recognition purposes?
And you're referring to authenticating the video when you're asking a witness about the video prior to admitting it into evidence?
Yes, Your Honor.
So because everything is going to be constructive in the nature, in the sense that it will be outside of the presence of the jury until it's admitted, you may freely play it and we'll assume that I've excused the jury so that you were able to lay that foundation. So you could assume that you're outside the presence of the jury for the purpose of laying that foundation.
Yes, Your Honor. And beyond that, we just ask that everything that was granted to the plaintiff be granted to the defense as well.
Okay, that is understood, and it is, the record will reflect that requests that were granted as to one party are granted as to both. Anything further?
No, Your Honor. With that, the defense is ready to proceed with opening statements.
Before we get to opening statements, I will just instruct the scoring judges that we're going to now hear opening statements from each party. Everyone should make sure, and this includes all of our spectators for the benefit of your viewing pleasure, that you should be in speaker view right now for the opening statements. And then when we get to witness examinations, you should switch it back to gallery view. So get yourself in speaker view right now. That button is in the top right hand corner of your screen that says view. And when you click there, you'll see either speaker or gallery. Get it on speaker for the opening statements. With that, Attorney Owen, you may proceed. I'm sorry, Attorney Stone, my apologies. You may proceed when you're ready.
Thank you, Your Honor. Good afternoon, Your Honor, members of the jury. My name is Owen Stone, and I represent the plaintiff Ethel Marks in today's case. Now, back when I was growing up, I used to spend summers with my granddad, and he had this old phrase that if you see a turtle on a fence post, it didn't get there by itself. I'll be honest with you, I didn't understand that phrase for the longest time, but now I do understand. I understand that it means common sense. And today's case is no different. I'd like to tell you the story of Jessica Marks. On March 24th, 2019, a 19-year-old girl named Jessica was on spring break with her friend. They decided to go to a bar together, and while they were there, Jessica was served 7 drinks and a full bottle of wine. While there, Jessica had a video recorded of her. In that video, she seems pretty drunk. Then, when Jessica went to leave that bar, Sonny's rooftop bar, at the end of that night, she got in her car and tried to drive home. She barely made it 1,000 feet before veering off the road and crashing. The crash was fatal. Jessica died that night. When the paramedics pulled her body out of the car, her blood alcohol level was 0.16, double the legal limit for an adult. Today's case is a tragedy. But who's responsible? Well, common sense and the law both tell you that Sonny's rooftop bar is responsible. Now, what I mean by that is the law we filed this suit under is called the Dram Shop Act, and it makes it so that bars are responsible to not serve obviously intoxicated minors. But the law gets more specific than that because it gives you as the jury the ability to decide whether Jessica was obviously intoxicated. In doing so, it gives you a long list of possible symptoms of obvious intoxication I'd like to show you now. And you can see that there's your job as a jury is to decide whether Jessica was showing those symptoms, but that's not what I want to focus on. Because in addition to this, in deciding whether Jessica was obviously intoxicated, you as a jury are assigned that you may and should apply your common sense. Apply common sense in deciding whether she was obviously intoxicated. Now, as the plaintiff today, we ask that you use your common sense when listening to her blood alcohol, listening to how far she drove, listening to how many drinks she was served, and watching the video yourself. With all of those exhibits and evidence, we ask that you ask yourself, was that girl obviously intoxicated? It's just common sense. Now, our burden as the plaintiff today is to prove our case by a preponderance of the evidence, meaning more likely than not. You can have reasonable doubts, but we have to prove 4 things. First, that Jessica was a minor. That's undisputed. Second, that she was served at the bar that night. That's also undisputed. We also have to prove that she was injured that night. That's, again, undisputed, which means that the one thing that we have left to prove is whether Jessica was obviously intoxicated. More likely than not. And we believe that common sense and the evidence will show that she was. But the defense may try and contest this by claiming that Jessica's death was her fault and that she didn't use her common sense. But members of the jury, the law places responsibility on bars to protect minors because the law understands that a bar and a responsible adult bar owner has more control than an obviously intoxicated minor. And if that bar owner ignores common sense, then that minor can get hurt. Jessica got hurt. Listen to the evidence and listen to your common sense, and you will find at the end of today's case, Sonny's Rooftop Bar liable. Thank you.
Thank you, Attorney Stone. Attorney Winn, whenever you're ready. But actually, it'll just give it like 5 seconds so that anyone making notes can finish making their notes, and then you can proceed. So when you're
Yes, Your Honor. Her decisions led to her death. Opposing counsel just stood before you and told you a story. He told you that Jessica Marks and Morgan Levin were served at Sunny's rooftop bar until Jessica Marks was drunk. But I noticed that when he told you that story, there were a few things he decided to leave out. He didn't tell you that the 6 days prior to going to Sunny's rooftop bar, Jessica Marks had drank alcohol, 5 of them. Then on Sunday, she went to Sunny's rooftop bar, but today you will hear that she intended to go hard because she wasn't ready to go home. And opposing counsel didn't tell you that today. So before going to Sunny's bar, Jessica Marks and Morgan Levin drank at Jessica's Airbnb. Even after committing to going hard, Jessica Marks still didn't take an Uber. She intended to drink and drive, and she would have done so if my client served them or not, and you'll hear that today. Now, my client today is the establishment Sunny's rooftop bar. Today, this establishment will be represented by Sunny Mehta, the owner and bartender of this bar. Now, on Sunday evening, Sunny Mehta saw Jessica Marks when she ordered drinks, when he dropped them off, and today you will hear that that's all. Today, Sunny Mehta will tell you about his training in intoxication. He didn't see the traits, so he continued to serve Jessica Marks. In today's case, the plaintiff must prove to you by a preponderance of the evidence that because my client served an obviously intoxicated minor, that led to Jessica Marks's death. But members of the jury, they'll fail to meet this burden. While you're hearing the evidence today, remember the word obvious. In order for Sunny Mehta to have not served Jessica Marks, she would have needed to be clearly and self-evidently drunk. You'll hear about Sunny Mehta's training in intoxication. You'll hear that if he didn't find those traits, there was no reason for him to not serve her. Now, today you will also hear from Sunny Mehta that on Jessica Marks's way of leaving the bar, she walked down the stairs perfectly. You'll hear she didn't grab a railing, she didn't trip, she didn't stumble, she walked straight out of the bar. And members of the jury, you'll hear today that led Sunny Mehta to believe that she was not obviously intoxicated, because one of those traits you will learn about is poor motor skills. Now, at the end of today's trial, you'll also be asked if we, the defense, prove to you by a preponderance of the evidence that Jessica Marks's death was caused, whole or in part, by her own negligence. I want to make it clear, it's not easy for me to stand here today and tell you to blame Jessica Marks for her own death. It's so hard not to let your sympathy for her friends and her family get in the way, but today we need to look at the facts, the evidence, and the law. Jessica Marks made the decision to drive 45 minutes to a bar. She made the decision to order every one of those drinks that you'll hear about today, and you will hear she made the decision to get in the driver's seat and drive home. Those were her decisions, not my client's. Her decisions led to her death. At the end of today's trial, I will stand again where I stand now and ask you to find the defendant not liable. Thank you.
Thank you, Attorney Winn. All right, I believe it will be the plaintiff that will be beginning their case in chief at this time. Is that correct, Attorney Stone?
Yes, Your Honor. The plaintiff calls Morgan Levin to the stand.
All right. Just give me one moment before we get started. Just want to make sure I have everything set here for myself. And as a reminder to all the scoring judges, this would be a good time to put your your video setting on gallery view since we're in examination time. All right, Attorney Stone, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Levin. Could you please introduce yourself to the court?
Good afternoon. My name is Morgan Levin.
And how old are you, Ms. Levin?
I'm 21 currently. I'm over at UCLA studying.
And how old were you in March 24th, 2019?
I was 19 that night.
How do you know Jessica Marks?
Well, Jess and I have been best friends since middle school, and we met at the animal shelter, both adopting our dogs.
And I'd like to talk to you a little more about Jessica. What was she like?
I mean, she was a happy person. She loved animals. You know, we worked at the animal shelter together in high school. She was always willing to help people out with whatever they needed. You know, she worked really hard at everything, and sometimes she liked to let loose.
You say let loose. What did that entail?
I mean, sometimes the two of us would go to parties or just blast some music in the car, you know, whatever we felt like.
Did those going to parties, did that ever include drinking?
Sometimes, yeah, it did.
So have you been around Jessica when she's been drunk before?
I have.
All right, thank you. Now I'd like to move on to the night of March 24th, 2019. When did you meet that night?
Well, Jess picked me up from my dorm room early-ish in the evening, and we went back to her Airbnb.
Did you have any plans for that night?
Not when we arrived at the Airbnb, but we made a plan to go out once we got there.
And where were you planning on going?
We wanted to go to Sunny's rooftop bar. We'd heard it was a really fun time, and it was our last night, so we thought it was a good idea.
Now, Miss Levin, I seem to remember a minute ago you just said that you were 19 at the time. So how were you planning on getting into a bar?
Well, Jess and I both had fake IDs that we'd been using that week.
Would you recognize those fake IDs today?
Yeah, I would.
Your Honor, let the record reflect we're now showing Exhibit 3 for foundation purposes. Miss Levin, do you recognize this?
I do. That was Jess's ID that she used.
And is this a fair and accurate depiction of the ID as you last saw it?
Yeah, it is.
And is this the ID that Jessica used on the night of March 24th, 2019?
Yeah,
How are you sure of that?
I saw it that night, and I'd seen it before when she was using it.
Your Honor, we now move to enter Exhibit 3 into evidence.
Any objection?
Yes, Your Honor, relevance. May I be heard?
Yes.
In today's case, it was already stipulated to the fact that on March 24th of 2019, Jessica Marks and Morgan Levin were underage. Therefore, the admission of this exhibit, which is just going to prove that they were underage, makes no fact in today's case more or less probable.
Attorney Stone, response?
Yes, Your Honor, we believe that Ms. Levin is in a unique position to authenticate this document. We just laid foundation that she has personal knowledge of how that exhibit was used that night. We also proffer that we have no intention of using this to prove that Jessica was a minor that night. We're using this document for credibility purposes on the cross of Sunny Meta, and we would like to authenticate the document in its time frame now.
All right, so the relevance of this document, I'm sorry, of this this exhibit, Exhibit 3, is solely for the purpose of attacking the credibility of the owner when he takes the witness stand?
Yes, Your Honor, but we believe that since we can't recall Ms. Levin, we believe that it's fair to authenticate the document now and clarify the full story of the usage of this document, as it provides a clearer picture to the jury. And again, we can't recall Ms. Levin, so we'd ask to do that now.
And is it your expectation that Mr. Mehta, Sonny Mehta, the owner, that he saw this driver's license or this fake ID?
Yes, Your Honor. We just believe that it's better to authenticate the document in its full story now, as Ms. Levin has a more complete picture, as she just testified to the foundation that we laid before.
All right. Anything further from Attorney Winn?
Yes, Your Honor, we ask that if opposing counsel is using this ID for someone else's direct or cross-examination, rather, that they admit it on that examination. Now, right now, by admitting it, all that it's showing is that Jessica Marks is underage, which, like I stated, that fact is stipulated to. And at this time, it is being used for an irrelevant purpose.
Okay.
Your Honor, do you need further response from the plaintiff?
No, I do not. I'm prepared to rule. So I'm going to overrule the objection with this understanding. So I'm admitting it conditionally. So in the sense that I expect that it will be linked up to the relevant purpose when you do examine Mr. Maida for the purposes that you've articulated, and assuming that that is tied up. So I'm admitting it under conditional relevance. Assuming that's tied up, that will remain in evidence. However, I invite the defense to feel free to object or to re-raise this objection at the time that this is being discussed with Mr. Maida, or after the time that Mr. Maida has testified. And I apologize, it may be Miss Maida, but for whatever it's worth, when the owner testifies, if the defense feels like the relevance has not been linked up, then they can renew this objection and I'll reconsider it. So the objection is overruled without prejudice for it to be re-raised at a later time. Exhibit 3 is admitted.
Yes, Your Honor.
Thank you, Your Honor. We ask that this exhibit be published to the jury at this time.
You may.
Thank you, Your Honor. Now, Ms. Levin, is this the ID that Jessica used that night?
Yes, it is.
Did you see her use that ID that night?
Yeah, it's how we got into the bar.
Thank you. Mr. Kapitzi, you can take that down now. Now, before you left for the Airbnb, did Jessica seem drunk to you?
No, she seemed fine.
When you were driving to the bar, did she seem drunk to you?
No.
When you got to the bar, was she displaying any symptoms that you would believe were drunk?
Well, we'd each had like a glass of wine a bit before, and she did start to show a few things. She was a bit, her eyes got a bit bloodshot, and she started to smell a little like alcohol.
And she was displaying these symptoms when she went, and did she display those symptoms when she went into the bar?
Yeah, she was starting to.
All right. Now, Miss Levin, I'd like to talk to you about what happened in the bar that night. Did you and Jessica order alcohol?
We did, yeah.
Would you recognize your receipt from that night?
I would. Yeah, I was the one who filled it out.
Your Honor, we let the record reflect we're now showing Exhibit 17 for authentication purposes. Ms.
Yes.
Levin, do you recognize this?
Yes, that's the receipt.
And is this a fair and accurate depiction of the receipt as you last saw it?
Yeah.
Your Honor, we now move to enter Exhibit 17 into evidence.
Any objection?
No objections, Your Honor.
All right, exhibit 17 is admitted.
Now, Ms. Levin, I'd like to take you through this receipt and see what drinks Jessica had that night. So let's start at the top. What's the Decoy Red blend?
It's a bottle of wine we ordered. I had a glass from it, and then Jess had the rest of them.
Let the record reflect we added that to the list of drinks Jessica had. Let's go to those 3 White Claws. Who had the first of those White Claws?
Jess did.
Let the record reflect we added 1 White Claw. Who had the second?
Jess had that one as well.
Let the record reflect we added that. And who had the third?
Jess did. They weren't really my thing, so she had them all.
Let the record reflect we've added 3 White Claws to the demonstrative aid. Now, who had the IPA draft?
I did. It was a pint of beer.
Who had the IPA can?
Jess had the can of beer.
And let the record reflect we added that to the demonstrative. And who had the green tea shot specials?
We each had one at the end of the night.
Now, and let the record reflect we've added that to the demonstrative. Does this list reflect all the drinks that Jessica had that night?
Not quite. There's at least one missing.
And what was that?
Well, Jess had some sort of mixer drink, a Captain and Coke, I think they called it.
And did she have any other drinks that didn't show up on your receipt?
I'm not positive, but it's possible.
Objection, Your Honor. Lack of personal knowledge as to the word have. May I be heard?
You may.
Your Honor, as Mr. Stone is saying, did Jessica Marks have these drinks? It's inferring the fact that she in fact drank them. However, Miss Levin does not know if Jessica Marks drank all of these drinks. She only knows whether or not Miss Marks ordered them because they're on the receipt and she knows she didn't order them. Therefore, we ask that Mr. Stone does not use the vocabulary have, as that's inferring the fact that she drank those, which she does not have knowledge of.
Mr. Stone, your response?
Yes, Your Honor. If you believe that foundation hasn't been met, we can offer more line of questioning as we proffer that the witness was there with Jessica when she had these drinks and did witness them being consumed. So we're happy to lay foundation if you deem it appropriate.
Just, Mr. Stone, I'm inclined to agree with you. I just want to clarify. I thought that the witness testified that she was with the decedent and saw her consume the drinks that are listed on this receipt. Is my recollection correct?
Yes, Your Honor. We were simply offering that if you didn't believe that the standard had been met, but she did testify that she was with Jessica at the time.
With Jessica, but is there a dispute? I guess is there a dispute as to whether Miss Levin saw Jessica drink those drinks? Has
Your
she
Honor,
indicated that she actually saw her drink those?
Your Honor, we believe that she did indicate that, but if you or opposing counsel disagrees, we again are happy to lay that foundation as we proffer in good faith that she did actually see that, and it's simply another. We are simply happy to add.
Attorney Winn, my recollection is that she has indicated that she was with her and did or saw her consume these drinks. Do you have anything further to add, or am I incorrect? You want to be heard on
Nothing
that
further, Your Honor.
Okay, I'm going to overrule the objection.
Thank you, Your Honor. Now, Mr. Kapitsi, you can take this down now. Miss Levin, I'd like to talk to you about Jessica's behavior at the bar. How was she acting as the more and more drinks were being served and drank?
Well, I mean, I could see, I guess, the symptoms getting worse. She got really loud and she started slurring a lot of her words. She was a bit sick, I guess, and her eyes got really bloodshot.
Did you have any depictions of this throughout the night?
Yeah, there was a video that I recorded of Jess that she'd wanted to put on her Instagram.
Your Honor, let the record reflect we're now showing what has been previously marked as Exhibit 10. Do you recognize this?
Yeah, that's the video I took of Jess.
And is this a fair and accurate depiction of that video as you last saw it?
Yes.
Your Honor, we now move to enter Exhibit 10 into evidence.
Any objection?
No objection, Your Honor.
All right, it's admitted.
Mr. Kapitski, if you could please play that video.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Miss Levin, was she acting like that throughout the night?
Yeah, she was.
Did Sonny ever comment on this behavior?
Yeah, he did. There was one point when Jess was going down the stairs at the bar and she stumbled right into him.
And did he say anything?
Yeah, he said, I hope this one's not dry. Or, sorry, that was later. He said, we might need to cut this one off.
And did they ever cut her off?
Never, not once.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good evening, or good afternoon, Miss Levin.
Good afternoon.
Now, I'd like to talk to you about your friend, Jessica Marks. You had known Jessica for 6 years.
Yeah, we were best friends in middle and high school.
Jessica drank alcohol throughout high school, didn't she?
I wouldn't really say throughout. Sometimes in high school she did.
And after high school, the two of you kept in touch when you went to different colleges, right?
Yeah, we did. FaceTime, Instagram, anything.
Now, you saw her over winter break in 2018.
Yeah, I did.
And for spring break in 2019.
Yeah, she came to visit me in California.
And during these breaks, you recognized that Jessica had been drinking a little bit more alcohol than she had in high school, correct?
I mean, I don't know if it was during those breaks that I realized I knew she'd been drinking a little, but I don't think it was much more.
Now, when you would go to parties, you would generally only have one drink. Isn't that true?
Yeah, that's true.
You would do that because you were the one who was driving home, right?
Yeah,
And Miss Levin, you recognize that driving after drinking is dangerous, don't you?
I do.
Now, I want to talk, you mentioned you've been around Jessica Marks when she's been drinking. I'd like to talk about what you know about Jessica when she is drunk. Now, you've seen her drink before, haven't you?
I have.
You saw her drink on the 2019 spring break trip, right?
Yes, I did.
On Monday, you saw her order a beer at dinner.
Yeah, I think so.
And at Tuesday, she ordered a beer from a beer hall.
Objection, Your Honor, pursuant to Rule 403. May I be heard?
Yes.
Your Honor, opposing counsel going through the list of other instances where Jessica drank throughout the week leading up to March 24th is irrelevant to today's case, and any minimal probative value is outweighed by substantial prejudice, as this testimony doesn't lay any foundation for any material fact in today's case or make any fact more or less likely. We're here about March 24th, 2019, and Jessica's drinking on that night, not any other night before that.
Attorney Winn, your response?
Yes, Your Honor. We're bringing in these facts because it's going to show that Jessica Marks had intended to drink throughout that week, and she intended to drink on March 24th of 2019. And now we're using these facts not for anything to prejudice the jury that she drinks often. Rather, and this witness has already stated the fact that she drank throughout the week. We're just further exploring that in order to paint that picture of she intended to drink. When I proffer outside the presence of the jury, later in this cross-examination, you'll hear that she intended to go hard, and she was doing that all week, Your Honor.
Your Honor, may I respond based off of the opposing counsel? Your Honor, with opposing counsel's response, we'd like to change our objection to a Rule 404, as if they're attempting to show propensity based off of the witness's prior behavior or Ms. Marks's prior behavior throughout that week leading up to the events of March 24th, 2019.
Attorney Stone, did you, I think I recall that during the direct examination, there was some discussion about what they were doing and what the Ms. Marks was doing earlier that week. And I think there was some discussion about her drinking that as Miss Levin knew it growing up since they've been friends. Is that right? I mean, I thought I heard you talk about Miss Marks's drinking in general as far as this witness knew.
Yes, Your Honor, we asked about general questions about whether she recognized Jessica being drunk before. We didn't go into specific instances and especially didn't talk about the week leading up to it. We believe that they're under different standards as we were asking general questions to clarify the witness's knowledge about drinking, but as opposing counsel just proffered, they're using this specific instances for a different purpose to show how Jessica acted at a later incident.
Okay. I'm going to overrule the objection. I will say that it is bordering on cumulative. So if we can get through this line of questioning sooner than later, Mr. Stone, you can feel free to re-raise an objection, and I would certainly entertain cumulative and potentially 403 at a later time. So overruled with that understanding.
Yes, Your Honor.
Yes, Your Honor.
Now, Miss Levin, on Wednesday, Jessica Marks ordered a glass of wine from California Adventure, didn't she?
That sounds right.
And on Friday, she ordered wine from a bar in downtown LA.
I think so, yeah.
And on Saturday, the two of you went bar hopping.
We did.
And then on March 24th of 2019, you went to Sunny's rooftop bar, didn't you?
We did go to Sunny's.
But earlier in that day, Jessica Marks picked you up.
Yeah.
You went to her Airbnb.
Yes.
At that time, Jessica drank 1 to 2 glasses of wine, didn't she?
Yeah.
Jessica Marks posted a picture of those wine bottles on her Instagram, right?
Yeah, she did.
You would recognize that post if I were to show it to you?
I would.
No, you recognize this Instagram post, don't you?
I do.
And you recognize this to be Jessica Marks's post from March 24th of 2019, right?
Yeah,
And this post has not been changed or altered in any way since you last saw it, has it been?
not that I can see, no.
And it's a fair and accurate depiction of her post.
Yeah, it's just her post.
Your Honor, at this time, the defense moves to admit what has been previously marked as Exhibit 5 into evidence.
Any objection?
Yes, Your Honor, pursuant to Rule 802, we believe this document is inadmissible hearsay.
Response?
Your Honor, if you wish, we can constructively redact the statements made by Morgan Levin. However, the statements made by Jessica Marks would be an omission by a party opponent due to the fact that Ethel Marks today is representing Jessica Marks, due to the fact that Jessica Marks is unavailable in today's case. Now, if you find that she's still not the party opponent, due to the fact that she is unavailable, and this is a statement against interest as it's going towards the fact that she was drinking alcohol and we've established she was underage, and Your Honor, this is admissible due to the fact that the declarant was not available.
What's the purpose of offering this photograph, Attorney Winn? What are you using it to show?
Your Honor, we will, may I proffer outside the presence of the jury to explain?
Sure.
Your Honor, we're going to use the hashtag go big or go home to show Jessica Marks's intent on that evening. Those were intentions to drink. Because she's not available and because that's a statement against her own interest, that makes that hearsay exception acceptable.
Your Honor, may I respond?
Yes, you may, Attorney Stone.
Your Honor, first for the party opponent only applies to who the witness's party opponent is. As Ms. Levin is not the party opponent to Jessica Marks, we don't believe that exception applies. And as for statement against interest, Rule 804.2, statement against interest, only applies if the statement clearly indicates criminal liability. The statement go big or go home does not clearly indict Jessica Marks in any kind of criminal conspiracy or expose her to legal action. If opposing counsel wishes to use that statement as the exception, we believe that this in no way meets the criteria, the strict criteria of Rule 804.2, which is that it clearly exposes her to legal liability.
Your Honor, may I be heard?
You may.
Your Honor, we agree with Mr. Stone in the fact the statement hashtag go big or go home on its own does not elicit any illegal activity. However, this picture is paired with 2 bottles of alcohol that say the start to a good night. Now, that's clearly showing the fact that they began drinking and planned to continue drinking. And therefore, in this context, that hashtag go big or go home is clearly going towards her intent of drinking alcohol.
Yeah. I'm going to agree. I'm going to overrule the objection on the basis of the argument, the last argument that Attorney Winn made, that I see this as, first of all, it's a photograph, so that's not a statement or hearsay. The start to a good night is the declarant's then existing mental or emotional state. And I think the go big or go home is not being offered for the truth, but rather to show her mental state of mind at that time, that's such that she was intending to be, to go big or go home, or to have, many drinks. So that's all obviously not conclusive, and you can make any arguments as to weight or what the significance is to the jury, but I'm going to overrule the objection and it may be admitted in full. Exhibit 5 is admitted. I do believe you said that you're okay with redacting constructively the comments by Ms. Levin.
Correct, Your Honor.
Okay, so with the exception of the last line will be stricken from the exhibit, the rest of it is admitted.
Yes, Your Honor.
Now, Ms. Levin, part of this caption says hashtag go big or go home, doesn't it?
It says that, but I don't know what Jess really meant by it.
But that picture, that caption is paired with a picture of wine, isn't it?
I mean, it is, but we didn't have all that wine. I mean, we each had like a glass.
Okay, Ms. Levin. Now, you would recognize a video of Jessica Marks at her Airbnb from that evening, wouldn't you?
Yeah, I would.
And now, do you recognize this to be that? You recognize this to be that video, don't you?
Yeah, I do.
And it's a fair and accurate depiction of the video Jessica Marks took at her Airbnb.
I'm pretty sure, yes.
It hasn't been changed or altered in any way since the last time you saw it.
Not that I can tell from this, no.
And you were with Jessica Marks when she took this video, weren't you?
I was.
Your Honor, at this time, the defense moves to admit what has been previously marked as Exhibit 6 into evidence.
Any objection?
Yes, Your Honor. Once again, to hearsay, we believe it meets a different standard than the last exhibit. Would you like me to further explain?
Sure.
Your Honor, your previous clarification was that first off, the exhibit being a picture limited its hearsay statements, and second, that due to the then existing emotional state of Jessica, that the statements she made were not going to the truth of the matter. We believe that this document and the statements contained in it do qualify as hearsay going to the truth of the matter. As opposing counsel, we believe is going to ask questions about specifically the statements that Jessica made and her intention behind them.
Attorney Winn, do you intend to, is this a video that has audio with it?
Yes, Your Honor, it does.
And do you, if it were admitted, intend to play it?
Yes, Your Honor.
Okay, so here's what we're going to do. We're going to assume we're outside the presence of the jury. Can you go ahead and play it for me, and then I'll hear the rest of the objection?
Yes, Your Honor.
Hey guys, we're going out tonight for a night on the town. We're going to a rooftop bar in Hollywood. Should be fun. You know, go hard or go home. Not ready to go home.
Okay, so Attorney Winn, what's your response to the objection? And just to clarify, my previous ruling was that the one statement about the start to a good night was a present sense impression, because it suggested that it was taken near or at the time of the thing being observed, that being the alcohol. The go big or go home was not being considered for its truth, but rather for intent. So with that clarification though aside, your purpose for offering this is what, or what's your response to Attorney Stone?
Your Honor, we're not offering any of this for the truth of the matter asserted, except for the portion where Jessica Marks says, go big or go home. I'm not ready to go home. Your Honor, that statement falls under the same hearsay exception due to the fact that she's unavailable. She's holding a glass of wine, which you will hear from Miss Levin. She's going towards the fact that this is a statement against interest, and therefore this is admissible due to the fact that she is unavailable today.
Your Honor, may I respond?
Yes.
Your Honor, the last image, as you pointed out, has a caption about the start of a great night, and then further contextualizes that the planning to continue drinking, which allows that statement of go big or go home in the previous exhibit to be an intention. We believe that this exhibit does not share that same qualification. We believe that the statement go big or go home does not meet the qualification of we don't believe it meets the qualification for inciting a specific legal action or exposing her to criminal liability as a statement against interest. And in addition, Ms. Levin, when asked about that statement, says she doesn't know what it means, meaning that any questioning that opposing counsel proffers they're going to make is also pursuant to Rule 602, lack of personal knowledge.
Attorney Stone, I agree with you. I don't believe this is a statement against interest, so I'm taking that off the table. My question is, as I glossed over it on the last objection, but Attorney Winn, can you speak to the issue of whether this is in fact a party opponent statement? Because my understanding is the party is Ethel Marks. And even though she's representing the estate of Jessica Marks, and admittedly, I would have to bone up on this, but do you have any perspective as to whether she can still be considered a party opponent?
Well, yes, Your Honor. Due to the fact that Ethel Marks is more of a legal perspective of the fact that she's the one who is physically suing Sunny's Rooftop Bar, that's because Jessica Marks cannot be here today to do so. Therefore, she would still be the party opponent as Ethel Marks is suing in her behalf.
Okay, here's what I'm going to do. I think that these videos and the evidence of what she was like before going to the bar is probative, almost regardless of what she's saying, since part of the issue here is whether and to what extent she was obviously intoxicated at times later in the night. So I think that this evidence, if for nothing else, would certainly be relevant and probative for that purpose. The way that she's speaking would be relevant for that purpose without regard to the truth of the matter stated. And I do think that it provides some circumstantial evidence of her intent and mindset going into her time at the bar, which would be relevant to your affirmative defenses. So and some of the issues on the plaintiff's claim. So I'm gonna overrule the objection, but I think
Yes.
it was well argued.
Yes, Your Honor.
Yes, Your Honor.
Now, Ms. McDougall, can we please play this video now in the presence of the jury?
You just to save
Hey
time.
guys, we're going out tonight for a night on the town. We're going.
Yes, Your Honor.
We could assume that it was played in front of the jury just for that to save some time.
Yes, Your Honor. Ms. McDougall, can we go back to that? Just the screenshot. Thank you. Now, at the end of this video, it's true that Jessica Marks says, "Go big or go home. I'm not ready to go home," doesn't she?
She did. I didn't want her to go back to Pennsylvania either.
Now, at this time, when she says this, she tips her glass of wine towards the camera, right?
Yeah.
Now, both times that Jessica Marks used this phrase, you would agree with me that alcohol was near her, right?
I mean, yeah.
Now, you would recognize a video of Jessica Marks from later that evening at Sunny's bar if I were to show it to you, wouldn't you?
Yeah, if it's the one I took, then yeah.
No, you recognize this video?
Yeah, I saw it earlier.
No, this is the same video you saw in your direct examination, isn't it?
It is.
Now, you're familiar with the fact that Jessica again says in this video, "Go big or go home," doesn't she?
Yeah, I mean, she does. I still don't know exactly what she meant, though.
Now, after she says that, she takes a sip of a seltzer, doesn't she?
Yeah.
Now, the bartenders were not present when this video was taken, were they?
No, but I mean, she was acting the way in that video the whole night. So, I mean, they saw her acting like that.
Okay, Miss Levin, but it's true that you only saw the bartenders when they took your orders and dropped off your drinks, right?
Yeah, every time they came over to the table and dropped off the drinks, and then that thing on the stairs as well.
Miss Levin, it's true. Jessica decided to order her drinks at Sunny's bar, didn't she?
Yeah.
She made the decision she was going to drive home after having those drinks, right?
I wouldn't say that. I wouldn't say she really had a plan for what she was going to do, honestly. We never talked.
She made the decision to drive home, right? When she got into the car.
Objection, Your Honor. The witness just said that they don't know what Ms. Marks's decision was, so we believe that this continued line of questioning falls under Rule 602, lack of personal knowledge.
Your Honor,
Sustain. I'm going to
Yes.
sustain the objection.
Yes, Your
And we
Honor.
ask that the question be stricken from the record.
Stricken.
But Miss Levin, it's true, you know that Jessica Marks got into a car accident, didn't she?
Yeah, she did.
And she was the driver, right?
Yeah, she was.
So she had decided to drive.
Objection, Your Honor. This is the same question repeated.
Your
Yeah.
Honor, may I be heard?
Briefly.
Your Honor, I've now laid the foundation that Miss Levin knows that Jessica Marks was the one driving. Therefore, she knows that she made the decision to drive that evening.
Yeah, I agree that that's a logical inference that can be drawn, but the witness has indicated that she doesn't know whether it was her decision. So for whatever it's worth, I think that answer will stand, and I'm going to sustain any objection to continue asking that.
Yes, Your Honor.
Yes, Your Honor.
Now, Miss Levin, you would agree with me that the bartenders didn't
Your Honor,
spend the entire night with Jessica
objection, Your Honor. My timekeeper is called time, so we ask that the questioning cease at this time.
Okay, I'm going to give one more question because you went over time a little bit as well on your direct. So from what I saw in the chat thing, so you got one more question and then we'll end the examination.
Yes, Your Honor. Miss Levin, you would agree with me that the bartenders did not spend the entire night with Jessica Marks, right?
No, that would have been weird. We saw them though when they were over.
Thank you, Miss Levin, and thank you, Your Honor. I have no further questions.
Okay. Is there a redirect, Mr. Stone?
No need, Your Honor.
Okay. Ms. Levin, you are excused. Thank you for your testimony. And Attorney Stone, do you have any further witnesses or evidence to present in your case in chief?
No, Your Honor. The plaintiff rests their case in chief.
All right. Plaintiff is rested. Defense, are there any motions for the court to consider anything before you begin your case in chief?
And no, Your Honor, I'm ready to call my first witness.
All right. Defense may proceed to call its first witness.
At this time, the defense calls Sunny Mehta to the stand. May I proceed?
You may.
Good afternoon. Would you please introduce yourself to the jury?
Good afternoon. My name is Sunny Mehta. I'm a former bar owner of Sunny's Rooftop Bar.
Now, how did you come to owning your bar?
Well, growing up in LA, I always wanted to play for the Lakers. I love basketball. And after I graduated high school, things didn't quite work out that way, but I knew I wanted to be around people. I wanted to be able to watch a lot of sports, and I wanted to have a good time. So I decided to open a bar.
Now, I'd like to talk to you about March 24th of 2019. Do you remember that evening?
Yes, ma'am, I do. That's when Jessica Marks came to our bar.
Were you working?
I was.
How many employees were working on that evening?
Well, it was a Sunday night, so we're a little slow. It was just me and our bartender, Frankfurt. He's a great guy.
No. Could you explain the layout of your Sunny's Rooftop Bar?
Of course. Well, we're in Malibu, right next to the coastline. And you walk in our bar, there's a flight of steps up. Then we got the first floor where the drinks are, and Frankfurt's there working the drinks. Then across from that, you have a staircase that goes up to the roof, and we have a beautiful view.
And do you remember where Jessica Marks was sitting on that evening?
Yes, ma'am. She was upstairs on the roof with most of our other customers.
Was Jessica Marks with anyone?
I believe so. She was with a friend. I think her name was Morgan Levin.
About what time did Jessica Marks and Morgan Levin arrive?
She got there at 9 o'clock that night.
Did Morgan Levin and Jessica Marks decide to order drinks that evening?
They did.
Were you ever trained on how to tell if someone is intoxicated?
Well, yes, ma'am. As a bar owner, I had to go through many stages of testing and certification in order to get my liquor license. And so with that, I was trained on how to identify the signs when someone's had too much to drink.
Now, what do you do if someone has had too much to drink?
Well, of course, we cut that person off.
How often do you have to do this?
Well, I would say it's about once a week. There's someone who I have to go up to them, say, "Hey, buddy, you know."
Objection, Your Honor. Pursuant to Rule 404B, this is inadmissible character evidence.
Your Honor, may I be heard?
You may.
Your Honor, we're not using this fact that because in the past, Mr. Mehta had cut off customers, that he would cut off a customer again. Rather, we're simply using it for credibility purposes, that he is familiar with the law and that he has cut off customers, he knows how to do it, and therefore, if he had the need to do it, he could have.
Your Honor.
Go ahead,
Sorry.
Attorney Stone.
Your Honor, we believe that the way opposing counsel proffered their argument, it still falls under Rule 404B, as opposing counsel ended their argument by saying that they were going to use this to show that Mr. Mehta would be able to act in accordance with that trait. It would be able to cut someone off because of their knowledge of the law. We proffer that that still is inadmissible character evidence, as they're trying to demonstrate that Mr. Mehta knew and would be able to cut someone off in a future instance based off of past events as his character evidence.
Your Honor, may I be heard?
Yes.
Your Honor, if I had simply asked this witness, do you know how to cut someone off, or could you have cut Jessica Marks off, that would have lacked foundation. This is a foundational question, just laying that foundation that he does know how to cut someone off, when to cut someone off, and therefore it's building his credibility on knowledge of the law.
Yeah, I do believe that the witness's testimony is going to an issue that is disputed in this case, and or relevant to this case as to whether he knew and or had procedures or had the ability to cut someone off, you know, and or at least was actively making a determination as to whether she was obviously intoxicated. So I'm inclined to overrule the objection. My concern is if you could just ask the question, and we'll assume we're outside the presence of the jury. I want to hear his answer, because I do hear Attorney Stone's point. Sounded like he was talking about, you know what, actually, I think it's okay. I'll watch for it. You can re-raise your objection if you think it's crossing the line into propensity, Attorney Stone. For now, I'm going to overrule the objection.
Yes,
Your
Your
Honor.
Honor. Now, Mr. Mehta, how often did you generally need to cut someone off?
I apologize. That question is sustained. How often is different than the other things we were talking about? So I'm going to sustain the objection as to that question.
Yes, Your Honor.
Yes, Your Honor.
Now,
But we ask that the question be stricken, of course.
Straight.
Mr. Mehta, what are the traits of intoxication that you look for in customers?
Well, ma'am, it's not really one thing that we look for. It's oftentimes a combination of factors. If someone's, passing out, if they're throwing up, if they're talking loud with a slurred voice, if they're not able to make an order, if they're not able to stand up straight, if they're doing things that don't really make sense, it's usually pretty obvious when we tell that someone's had too much to drink.
Now, I'd like to talk to you about Jessica Marks. About how many times were you at her table?
Well, throughout the 3 hours she was at the bar, I probably came to her table 8 to 10 times.
And have you been shown any videos of Jessica Marks from your bar on that evening since that night?
Since that night, I've been deposed, and the attorney showed me a couple of videos, yes.
And would you recognize the video at your bar if I were to show it to you?
I believe I would.
Now, Mr. Mehta, you saw this video earlier. Did you see this video earlier today?
I saw it earlier in trial today, but I did not see this on the 24th.
Right. And does it look like it's the same video that we watched earlier?
It looks like that way to me.
Now, were you present when this video was filmed?
No, ma'am. I wasn't there when they were recording this. I was either downstairs in the bar or at a different table that night.
Do you know how Jessica decided she was going to get home that evening?
I did ask her. At one point in the night, I noticed her friend Morgan looked like she was a little drunk. So I looked over at Jessica and I said, I hope this one's not driving.
Now, you heard today Morgan Levin say Jessica Marks tripped on the stairs and fell into you. Is that true?
No, ma'am. That never happened when I was there that night.
Mr. Mehta, was it at any point obvious to you Jessica Marks was intoxicated?
No, not at all. She didn't show any of those classic signs that I told you I look for. She wasn't slurring her speech. She wasn't stumbling, wasn't falling over, passing out. None of that.
Thank you, Mr. Mehta. Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Mr. Mehta, I'd like to begin by having you read with me along a police statement that was taken that night. Let the record reflect we're showing Exhibit 23, which has been pre-admitted. Please read the lines highlighted in yellow silently while I read them aloud.
Okay.
Marks's BAC at the time of the crash was 0.16. In California, it's illegal to drive with a BAC of 0.08 and illegal for someone younger than 21 to drive with a BAC of 0.01. Did I read that correctly?
Yes, you did.
So as far as this report is concerned, after leaving your bar, Jessica had a BAC of 0.16, didn't she?
That's right. I had no idea.
And that's double the legal limit for an adult, right?
That's correct, sir.
That's 16 times the legal limit for a minor?
That looks, I believe it says that on the report.
Thank you. You can take that down, Mr. Kopitsky. Now, I'd like to talk about your time at the bar with Jessica. Now, you claim you checked Jessica's ID on the night of March 24th, 2019, right?
Sir, at my bar, it's a policy. Anyone who looks younger than 45 is going to get carded.
Right. Well, I'd like to show you that ID. Mr. Kopitsky, if you could please pull up Exhibit 3. Now, this ID is an obvious fake, isn't it?
Yeah, you know what? I don't recognize seeing this ID. I don't remember seeing it on March 24th. I know I check hundreds of IDs every week. I don't remember seeing this one.
Mr. Mehta, that wasn't my question. My question was, this ID is an obvious fake, isn't it?
Yeah, taking a look at it, you look at some of the information that's missing there. It doesn't have a yeah. There's a lot of factors that I could go through, but yeah, it's pretty obvious fake.
Right. I mean, it's just common sense that this is a fake ID, isn't it?
Yeah, it wouldn't take me long to look at this and tell that it's not a legitimate ID.
Now, you claim you don't serve anyone who uses a fake ID, right?
No. And sir, I don't remember seeing this ID. If I let someone in with this ID, I must have been a mistake.
But you served Jessica Marks alcohol on the night of March 24th, 2019.
Unfortunately, I did.
And this is despite the fact that she showed you the obviously fake ID, right?
I don't remember her showing me this ID in particular. Again, sir, I serve hundreds of people every week. I don't remember all the cards that I'm shown.
Mr. Mehta, is it your testimony today that you did not see Exhibit 3 on the night of March 24th, 2019?
Yes, sir. That's what I told the lawyers. I told them I didn't recognize seeing that particular ID.
Mr. Kapitsky, if you could please pull up Mr. Mehta's deposition, page 10, line 9. You recognize this, right?
Yes, that looks like, I don't see the title page of it, but looking at the answers there, I believe this is the deposition that I completed with the attorneys.
Yes, this is your deposition that you were sworn and signed in, right?
It appears so, yes.
Yes. And you recognize that all these answers were given under oath, right?
Of course.
So please read along silently while I read aloud lines 9 and 10. Question: how can you be sure you saw exhibits 3 and 4? Answer: I card anyone who looks younger than 45. Did I read that correctly?
That's correct. I said I card anyone who's younger than 45. But if you actually look at line 1 and 2, I said I don't have a specific memory of the ID itself, and I stand by that today. I don't remember seeing a particular ID.
Mr. Mehta, you are sure that you saw Exhibit 3 on the night of March 24th, 2019, correct?
No, sir. I'm sure I must have carded Jessica that night, but I don't remember seeing that specific ID, like I said on line 2 right there.
So are you lying in your deposition when you say that you're sure you saw Exhibit 3 because you carded anyone under 45? Are you lying now when you're saying that you don't remember that
Your
ID
Honor,
at all?
argumentative.
Your Honor, 2 responses. First,
Hold,
we're
hold, hold.
asking. Oh,
Continue.
okay. Mr. Mehta, I'll ask you again. Are you lying in the deposition on line 9 and 10 where you say that you're sure you saw that ID because you card anyone who looks under 45? Or are you lying now when you say that you don't think you saw that ID?
Sir, I'm trying to tell the truth in both situations. I told you, I'll say it again. I don't remember seeing this specific ID, but I always card people.
All right,
I know I must have carded Jessica that night. I just don't remember seeing it, this specific ID that night.
Mr. Kapitsky, you can take the deposition down now. I'd like to talk to you about your time with Jessica and how she was acting. Now, you interacted with her 8 to 10 times, didn't you?
That's right.
You served her, right?
Yes, I was the one bringing up the drinks from downstairs.
You cleaned up the drinks, right?
Yes, I was coming to and from their table.
You took orders, right?
That's right.
Now, you were shown a video, you saw a video in today's case, right? From Jessica at the bar that night?
At the bar, I did, yes.
And based off that video, you believe that you'd be possibly concerned by her behavior, right?
Yeah, again, like I said on direct, I wasn't there when this video was filmed. I don't know why it was filmed. But yeah, based on what I see here, I would have been concerned.
Right, she could have been drunk, right?
Again, it's hard to tell from a short clip, but I think it's possible.
Now, Mr. Mehta, despite this video, and despite everything you saw, despite the 8 to 10 interactions with Jessica you had that night, you claim that in all those interactions, she was perfectly sober?
Sir, I didn't see any of the classic signs of someone not being able to function. I mean, at the end of the night after she had all those drinks, I watched her walk down the stairs of the bar without any problems.
Mr. Mehta, I ask that you please provide a clean answer for the record. You believe that in your interactions with Jessica, she was perfectly sober?
As far as I could tell, sir, I would say she was.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor, may I proceed?
You may.
Now, Mr. Mehta, opposing counsel asked you about Jessica Marks's blood alcohol content. Do you use a breathalyzer at your bar?
No, ma'am. Again, if I had known that she had that blood alcohol concentration, I should have cut her off, and I feel terrible about her death. But
Right.
based on sorry.
No, you can proceed, Mr. Mehta.
Yeah, ma'am, based on what I saw Jessica look like at that bar, I didn't see any reason to cut her off when she was there that night.
So did you have any way to know what her blood alcohol was?
No, ma'am, I can't test her. I can't see that.
Now, Mr. Stone also asked you a lot of questions about Jessica Marks's fake ID and whether or not you recognized it. Can you explain that for the jury?
Of course, like I said to Mr. Stone, I know I must have checked that ID, but I check hundreds of them every week. I don't remember seeing that specific image, but I assure you, I wasn't lying in my deposition. I'm not lying to you now.
Thank you, Mr. Mehta. Thank you, Your Honor. I have no further questions.
All right, the witness may be excused. Does the defense have any further witnesses or evidence to present on its case in chief?
No, Your Honor. At this time, the defense rests and is ready to proceed with closing arguments.
Okay, so we're going to now hear the closing arguments from each party. I'm going to ask everybody to switch back to the speaker view, which is in the top right-hand corner of your window. Take a moment to go ahead and do that. And while we're waiting, I just want to inquire of counsel two things. First, I assume it is the closing arguments are plaintiff and then defense. Is that correct?
Yes, Your Honor, but we would ask to reserve any remaining time for rebuttal.
And you do have an opportunity for rebuttal. That is your request is granted. And then my second question is are you guys ready to proceed, or do you need a 2-minute break?
Your Honor, the plaintiff is ready to proceed.
The defense is ready to proceed as well, Your Honor.
Well, let's get it on. All right, plaintiff, when you're ready.
Your Honor, members of the jury, may it please the court. Perfectly sober. Mr. Mehta claims that Jessica was perfectly sober in their interactions that night. Despite her blood alcohol being 16 times the legal limit for someone her age, despite the video where he says she could be drunk, despite the 8 to 10 interactions served over the course of 7 drinks and a full bottle of wine, Mr. Mehta wants you to believe that Jessica was perfectly sober. Members of the jury, it defies common sense. Mr. Mehta continues to claim that Jessica was perfectly sober, but the undisputed facts show that she wasn't. There are a series of 4 undisputed facts in this case. Jessica's blood alcohol was 0.16. Jessica tried to leave the bar, but couldn't even make it barely 1,000 feet before crashing. Jessica was served 7 drinks and a full bottle of wine, and Jessica recorded a video of herself acting drunk. These 4 facts are undisputed. We ask that you look at them with your common sense, and you will see that Jessica Marks was obviously intoxicated. She was not perfectly sober. Now, in fact, members of the jury, you can make your decision today based off of solely the undisputed facts, because there's a jury instruction in today's case that the court will read to you at the end of today's case, which allows you to use circumstantial evidence. But I'd like to show it to you now for clarity. Now, please read with me the lines in red that say that circumstantial evidence is one or more facts that logically lead you to believe the truth of another fact. And then if you look at the bottom, you can see that you can make your decision based off of solely circumstantial evidence. One or more facts that logically lead you to believe the truth of another fact. If you see a turtle on a fence post, it didn't get there by itself. If a girl has a blood alcohol of 0.16, she was not perfectly sober. If a girl can't make it 1,000 feet before crashing her car after going to a bar, she was not perfectly sober. If a girl was served 7 drinks and a full bottle of wine, she was not perfectly sober. And if that girl records a video of herself not acting perfectly sober, she was not perfectly sober. She was obviously intoxicated. It's just common sense. Now, our burden today was to prove to you by preponderance of the evidence, meaning more likely than not, that Jessica was obviously intoxicated when being served. And as I said, you can base your decision off of the undisputed facts. But even if you don't believe that's enough, that's not all we've brought. Because Morgan Levin told you on the stand today about the symptoms Jessica was experiencing when she walked into the bar. She was experiencing bloodshot eyes, smelling like alcohol, slurring her speech, and speaking loudly. She was drunk, members of the jury. She was obviously intoxicated when she walked into the bar. She should not have been served that first round of drinks, but Sunny Mehta ignored common sense, ignored the obviously intoxicated minor in front of him, and served away. Now, while I mentioned Sunny Mehta, I'd like to also remind you of Sunny Mehta that they lied to you on the stand today. They lied under oath. Because they told you that he checked Jessica's ID that night. But we know that that ID was a fake. He then went on to tell you that he doesn't serve people who use fake IDs, while also claiming that he served Jessica that night. Members of the jury, one of those statements must be a lie. He lied to you about his ID checking. He lied to you about whether that was the ID he saw. And he lied to you about perfectly sober. Because members of the jury, a girl with a blood alcohol of 0.16 was not sober. A girl who can't get off the road without crashing 1,000 feet from the bar was not perfectly sober. Jessica Marks was obviously intoxicated when served. At this time, we reserve the rest of our time for rebuttal.
Okay. Defense Attorney Winn, whenever you're ready.
Her decisions led to her death. Today, you heard the plaintiff tell you a story. A story where if Sunny Mehta didn't serve Jessica Marks, she would still be alive today. They're asking you to believe that story based on feelings. Based on feeling sympathetic for Jessica Marks's family and for her friends. Now, members of the jury, it's hard for me to stand here and tell you not to feel sympathetic for them. But today, we ask you to put your feelings aside, look at the facts, look at the law, and look at Jessica Marks's negligence. Today, with the evidence shown, you saw Jessica Marks intended to go big or go home that evening. But she wasn't ready to go home. She intended to go big. You heard she not only went hard, but that was her plan. Her premeditated intent. If Jessica had been cut off at Sunny's bar, she would have gotten alcohol somewhere else. She already drank at the Airbnb earlier that day, and you heard she drank at 5 other places throughout the week. Does it really make sense to think that if Jessica Marks wasn't served at Sunny's bar, she would have just gone home? Today, the plaintiff had to prove to you by a preponderance of the evidence that my client served an obviously intoxicated minor. And because they did so, she got into a car accident. They failed to meet that burden. They failed to prove that in front of Sunny Marks and Franklin Johnson, that Jessica Marks acted obviously intoxicated. Now, members of the jury, let's get this straight. Jessica Marks was a teenager. She was 19 years old. Of course, she didn't want a bartender noticing she was drunk. In that video, she was comfortable. She was with her best friend. Now, on closing arguments, even Mr. Stone said she was acting drunk, and that's exactly what she was doing. So Sunny Mehta didn't cut her off. Why not? Because there wasn't a reason to. There was nothing to stop. Sunny Mehta only saw Jessica and Morgan when she went to take their orders and when he went to drop them off. Within these times, he did not perceive the traits of obvious intoxication that he told you he's taught to identify. So then why didn't he stop her from driving home? Today, Sunny Meta told you that Jessica Marks walked down the stairs. She didn't grab a handrail, she didn't trip, she didn't stumble, and then she walked out of the bar. There was no reason for him to believe she was obviously intoxicated. And now today, Morgan Levin told you a different story, told you on her way out, Jessica Marks tripped, fell into Sunny. Sunny mentioned that she shouldn't drive home. Members of the jury, who are you going to choose to believe? A drunk teenage girl or a trained, sober bartender? Now today, we also had a burden. We had to prove to you by a preponderance of the evidence that it is because of Jessica Marks's own negligence she got into a car accident. That decision led to her death. Now, Jessica Marks made a lot of decisions that evening before her accident. She decided to drink wine before leaving her Airbnb. She decided to drive to a bar 45 minutes away. She then decided she was going to drive home, and that's what led to her accident. Members of the jury, every drink she ordered was her own decision. It's as simple as this. If Jessica Marks didn't make these decisions, she wouldn't have gotten into her accident. Now, you just heard opposing counsel stand before you and tell you things about her being perfectly sober. Members of the jury, that's not the line she needed to be cut off at. People are allowed to be buzzed. They just can't be obviously intoxicated. Mr. Stone stood before you and kept telling you that Sunny Meta said that she was perfectly sober. Well, it doesn't matter if she was perfectly sober or a little bit buzzed. All that matters is he didn't detect the traits of obvious intoxication. All that matters is she decided to drink that evening and she decided to drive home. Now, Mr. Stone also just stood before you and told you about her blood alcohol. The members of the jury, again, you heard today that that doesn't matter. You heard from Mr. Meta. He said he didn't know her blood alcohol content, but also that's not the law. That's not his training. His training wasn't to give everyone a breathalyzer, find out their blood alcohol and cut them off if it was too high. Their training was to see if she was obviously intoxicated. Members of the jury, Jessica Marks made decisions that led to her death. Find the defendant not liable. Thank you.
Thank you, Attorney Winn. And I'll hear the rebuttal from the plaintiff.
Yes, Your Honor. Your Honor, members of the jury, may it please the court. The defense just told you that Jessica's decisions led to her death. They gave you examples. They told you things that Jessica did that night, her decisions to drink and drive, but they neglected one very, very important detail. Who could have stopped those decisions? Who had the common sense, or needed the common sense to stop those decisions? In fact, who had the legal duty to stop those decisions? Because if the defense and I agree on one thing, it's that Jessica Marks was a teenager. Jessica Marks was drunk and could not make the right choices for herself, but the sober bar owner should have. But that doesn't mean he did. Because members of the jury, opposing counsel ask you to place their faith in Sunny Meta, to believe when he tells you that he didn't detect any symptoms. Opposing counsel then went on to claim that it doesn't matter whether she seemed perfectly sober or a little buzzed. That's an exact quote, but members of the jury, it does matter. Because it matters whether Sunny Meta was willing to look you in the eyes under oath and tell you that Jessica was perfectly sober. Meanwhile, we all know, the defense knows, you know, I know, it's undisputed that Jessica's blood alcohol was 0.16, 16 times the legal limit for Jessica's age. It doesn't matter whether Sunny Meta could check that. It matters that it's true. It matters that Sunny Meta told you that she was perfectly sober under these circumstances. Sunny Meta is not trustworthy. Sunny Meta lied to you on the stand multiple times. Members of the jury, the opposing counsel told you that Jessica would have gotten alcohol somewhere else. They needed to prove that to you by a preponderance of the evidence, but there's zero evidence of that in today's case. We ask that you look back through the record and think about what every witness said. No witness testified that on that night Jessica had plans to go further. But we do know that one person could have stopped any and all plans to her drinking at Sunny's rooftop bar. And that was the defendant. The defendant ignored common sense and let Jessica drink. Find the defendant liable. Thank you.
Thank you, Attorney Stone. Thank you, counsel. At this time, the closing arguments have concluded. The trial is concluded, and this matter will be submitted to the jury for deliberation. Thank you, counsel. I'm going to ask everybody to just stay patient for a moment. We are going to have the judges complete their ballots and click submit. I'll ask that everybody stay on until everyone has submitted their ballots, and then we'll do brief comments. So hang tight for a few minutes. Advocates, if you'd like to take a quick bathroom break, just come back in about 2 minutes.